Welcome back to the Environmental Law Monitor. I'm your host, Daniel Pope. This podcast is brought to you by Bracewell LLP's Environment, Lands, and Resources Group. We're glad you're here with us. The podcast that you're about to hear is over West Virginia versus EPA. I was joined by two of our partners at Bracewell, Jeff Holmstead and Jeff Oldham, and they helped us break down the Supreme Court's recent decision in West Virginia versus EPA. And the conversation, at least in my view, was so good that we kept going on and on, longer than our usual episode time of around 30 minutes. So we've decided to break up that conversation into a couple of episodes. What you'll hear for our first episode is our discussion of the case itself, the issues involved in the case, the different opinions issued by the court and its justices. Going into recording the podcast with Jeff Holmstead and Jeff Oldham, I knew it was going to be good, but you really couldn't ask for two better conversation partners to break down the significance of the decision that we've seen at the close of the Supreme Court's last term. So I hope you're looking forward to that discussion. We're going to be having a second episode that's not focused so much on the legal issues and the case itself, but possible implications of West Virginia versus EPA for circuit and district courts, for the Environmental Protection Agency's efforts to address climate change moving forward, for the Biden administration's initiatives and so forth, as well as the larger question of how the major questions doctrine might affect other agencies and currently ongoing rulemakings. So I hope you enjoy our conversation on the decision itself. And I hope you stay tuned for our next episode, breaking down how the decision might affect federal agencies and this administration. In today's episode, we're going to discuss the Supreme Court's recent decision in West Virginia versus EPA. Now, if you follow the court or environmental law issues really at all, you'll likely have come across tweets, Instagram and Facebook posts, news articles, and all manner of hot takes celebrating or decrying the Supreme Court's decision in this case, which was a review of EPA's authority under a provision of the Clean Air Act to encourage coal-fired power plants to shutter in favor of other kinds of electric generation. Well, from what I've seen, those tweets, those posts, those hot takes generate quite a bit of heat, but very little light. And if I can use my single allotted pun early in the podcast, that's something that advocates of both the Clean Power Plan and the Affordable Clean Energy Rule would disfavor. So instead of taking stock of the case with a sort of hot takes and shooting from the hip, we're going to do something a little bit different and discuss the decision in detail and its implications for both environmental law and more broadly for administrative law. Because I think all of us today recognize that this case is a pretty significant decision for both of those contexts. And I'm joined by two colleagues today who are going to provide quite a bit of insight on both of those topics. First, joined by Jeff Holmstead, a partner in our Environment, Lands, and Resources Group, who joins us from our Washington, D.C. office. And we're joined by Jeff Oldham, a partner in our Litigation and Appellate practice group in Houston and Austin. Because their names are similar and their insights will both be extremely helpful, you may have a tough time keeping them straight with just the audio to go on, so I'll do my best to keep it sorted. First, what we're going to do is we're going to discuss the opinions, the three opinions in the West Virginia versus EPA decision. Obviously, we'll be spending a lot of our time with the majority opinion, but the concurrence and the dissent both merit a few remarks. And then our guests, the Jeffs, will help us understand how the result in West Virginia versus EPA will shape environmental law and policy and administrative law as well. So thank you both for being with me this afternoon. Jeff Holmstead, I'd like to go to you first. Could you tee up the issues that were presented to the court in West Virginia versus EPA and just sort of set the table for us? I know that we're all sort of familiar with it, and if somebody's listening to this podcast, they probably have a basic understanding of what was presented to the court, but just so we're all speaking the same language, could you go ahead and tee that up for us?
Sure, I'd be happy to. As you said, I think most people listening will probably be somewhat familiar with the case, but it really revolves around a rule that the Biden administration issued back in 2015 called the Clean Power Plan. It was promulgated under Section 111D of the Clean Air Act, which was a provision that had only been used 3 or 4 times before, because it only applies to pollutants that are neither hazardous air pollutants or criteria air pollutants. And since almost everything you can imagine is one or the other, Section 111D is rarely used. It was used because CO2 is not either a HAP or a criteria pollutant. And historically, it had been used, again, in just a handful of cases to get existing facilities to install pollution controls. EPA determined that when it came to reducing CO2, that really wasn't feasible. And instead, it read the statute creatively to require what they called generation shifting. And in essence, what that did was create a rather complicated system that over time would require coal-fired power plants to generate less and to shut down. I don't recall the exact numbers of plants that they expected to be shuttered as a result of the case, but it was a fairly significant shift from coal to natural gas, and then even more towards renewables. And so that's sort of at the heart of this case was that plan that the Obama EPA issued. There's a lot of issues here, but ultimately, what the Supreme Court did in the case was, I think, use its review of that rule as a way to define and embrace something called the major question doctrine. And I know we'll get more into that. But ultimately, what the court said in brief is that in some extraordinary cases, and it listed some factors that would make cases extraordinary, including vast political and economic significance, or an assertion by an agency of a type of authority that it had never really employed before, that the court would not use a traditional sort of statutory interpretation analysis, but instead said that was only permissible if Congress had given a clear statement that they intended to give that authority to an agency. And since the agency could not point to any evidence in the statute that that's what Congress clearly intended, they declared that approach to this provision, this generation shifting, was unlawful.
Yeah, that was one of the things that stuck out to me about the Clean Power Plan in the first version of that plan that we saw in 2015. I typically associate emissions limitations with point sources, stationary sources, and you between using emissions limits or control technologies, you address emissions from those point sources. But as you pointed out, the Clean Power Plan had sort of a complicated, almost 3-step framework where you would install heat rate improvements, but then you would eventually use other kinds of regulations to nudge or push the electric generation industry in a particular direction.
Yes, I think that's fair.
Well, since you've already started taking us there and taking us into the major questions doctrine and the majority opinion and the way that the court resolved the case, which was a 6-3 decision in favor of West Virginia and a number of other states who had challenged the Clean Power Plan and the rescission of the Trump era rule, which was really sort of we call it the Affordable Clean Energy Rule. And that applied just to heat rate improvements. So it was kind of a third of the Clean Power Plan. But they were,
can I interrupt? The reason I didn't even talk about that is anyway, we could talk about the procedural history for an hour because it's kind of complicated. So I almost think we ought to not try to get into the ACE rule and what that did and whether it sprang back to life. Otherwise,
I think you're right. I started thinking about that myself.
I think one way we could do it is after talking about the opinion. There is the question Jeff Holmstead, you and I talked about in our last panel, which is why did the court take this? And now that we know what they held, we know a little bit more about why they took the case. And that may be the context in which to point out it was a bit of an odd procedural spot where the court took this case.
I think I've got a way to sort of introduce that. And maybe I'll go to you, Jeff Oldham, to talk a little bit about the major questions doctrine, and we can discuss the majority opinion from that. So, Julia, we'll go back to the conclusion of Jeff's intro remarks, and then I'll take it from there. So that's a good overview of what the Supreme Court did in West Virginia versus EPA. And, I didn't mention this in the intro, but we've had the benefit, and some of our clients will have had the benefit from hearing from both of you at our spring environmental law seminar. We were discussing this case and a few of the other cases that the Supreme Court has before it, and some of the major environmental cases that we're going to be seeing roll out over the next few months. But back then, that was in May. We did not know what the Supreme Court was going to do. And I think we had a hint that the major questions doctrine would play some role in the decision. But this majority opinion had major questions doctrine written all over it. And then there was a concurrence that also had major questions doctrine and clear statement rules written all over that one as well. So, Jeff Oldham, could you, in the context of the majority opinion, bring some clarity to what the major questions doctrine is? How did the Supreme Court address that in its majority opinion? And give us some information on where that is and what the state of the major questions doctrine is today after this case.
Sure. And, leading up to this case, and I think maybe I said something like this when Jeff Holmstead and I were giving that presentation in May, which is that, the next time the court says something about the major questions doctrine is when we'll be able to talk about what the major questions doctrine is, because it's, on the one hand, it's something that the dissent charge had never been applied before, at least by name. Whereas, by my count, it's been applied, potentially 3 times in the last 12 months, if you look at some of the cases and what they cited. So this does appear, in the dissent charges that this is the first case in which a majority of the court has actually applied by name the major questions doctrine. They, cite to a number of the cases where it comes from. And as I, just mentioned, those cases are ones that include, in the last year, the CDC eviction moratorium case, the OSHA vaccine mandate case, and then a number of other cases going back several decades in terms of, whether the FDA can regulate tobacco or things like that. And so leading up to this case, talking about all that prior precedent was interesting because they use the major questions doctrine in different ways depending on the case. At times, like in one of the Obamacare cases, it was cited as a reason not to apply Chevron deference at all. So sort of Chevron step 0. Other cases, it had been applied at Chevron step 1 as sort of an interpretive tool on how to interpret the statute. And then in other cases, it was a Chevron step 2 type of analysis of, okay, now that the statute's ambiguous, we're going to go this way rather than the other way because of the, cases and the principle underlying the major question doctrine. And that was, for example, even just the CDC evictions case. That was one where it seemed to be the tiebreaker once the statute was found ambiguous. What the court did in this case was much more similar to what it did in the OSHA vaccine mandate case, which is it didn't talk about Chevron at all, and it didn't really talk about it as an interpretive tool. It simply said it's a doctrine that's a clear statement rule that when it's triggered, when it's an extraordinary case that triggers the major questions doctrine, Congress has to clearly authorize the agency to do that. And if they don't, that's it. And so it's sort of the way that the court applied it here, again, for the first time by name, apparently, it, used it in this fashion that's potentially a little bit different than some of the other cases that they've relied on. And Jeff Holmstead talked about some of the factors, and it's interesting reading both the majority and the concurring opinion by Justice Gorsuch. They just cite all the different cases and all the different factors that have been present in some of the cases. Sometimes it is an agency is using a long extant statute to do something groundbreaking or transformative with its powers. Another factor sometimes is is it going to impact millions and people and billions of dollars? Then that's a sign that there's a major question. Those are just a couple of examples, but the court's opinion and the concurrence both go through different factors and maybe even emphasize different ones than each other about why this is a major question. So I think we got to. Sorry.
Oh no! So we talked a lot about the major questions doctrine, and it seems like and I would agree with you, Jeff. The court has talked quite a bit about the major questions doctrine. If this is the first time when it's been labeled as such, maybe that's the case. Although I know that people have been writing and talking about the major questions doctrine for some time. There was something there in previous cases that people saw, that people observed, that people either praised and invoked in the case of West Virginia and other states challenging the CPP. And some people decried it and said this isn't really a thing. But there's been something floating out there, and I think your remarks are helpful because while we do have this case pointing to sort of a lineage of cases and saying, hey, this is the major question doctrine. It's real. It's here to stay. And we'll get into this in a little bit when we talk about the dissent. It's still a little nebulous. We get this impression that, yes, if there's a significant regulation coming from an agency that relies on sort of a new interpretation of its authority, especially a new interpretation of authority related to a statute or a portion of a statute that it hasn't invoked particularly frequently, that's going to raise some major questions doctrine red flags. But there are a lot of other questions about how are agencies supposed to infer limitations on their authority from what the Supreme Court has given as guidance here. So what would you say, and this I think goes to both of you, coming from this case, are sort of the key features of the major questions doctrine, if you had to summarize it in 30 seconds or, in an elevator? What would you say those basic constituent elements are?
Can I interrupt? That's been a criticism that a lot of people have raised, that this is I was on a discussion the other day where someone called it judicial autocracy, that they'll decide what's a big deal and what's not. But that's the way cases always work. If somebody claims that it's a major question, they'll point to the prior cases and say, this is like those cases. And someone else will say, no, it's not like those cases. They'll be distinguished. And I do think that we don't necessarily have a complete list of factors that may go into that determination, and that will be fleshed out over time by the Supreme Court and likely by other courts, especially the D.C. Circuit. But I think we've kind of captured them. But I think when I think about it in these other cases, if you have an agency that's doing something that seems completely out of the ordinary compared to the way that they've done things in the past, and especially if they're regulating in an area that is outside their traditional scope of regulatory power, that raises questions, and the court's going to take a closer look at that. So Jeff Oldham, I don't know if you agree with that, but the criticism, at least in my mind, seems a little misplaced, because there may be other factors that courts decide warrant specific scrutiny here, but it's almost like a common sense interpretive canon that, if something's really a big deal, you want to make sure that this is really what Congress intended for the agency to be able to do. So,
sort of like I know it when I see it.
Yeah, I certainly think that's what the dissent would charge, is that this is I know it when I see it kind of a doctrine. But to Jeff Holmstead's point, all these factors have been cited in all these different cases. Congress has to speak clearly when it wants an agency to do something that is of vast political and economic significance. And as Jeff said, when an agency, when there's I think maybe the dissent used the mismatch, when there's a mismatch between an agency's expertise and this, grand, vast power that it's wielding, then that's another sign of a major question. So, I think in some ways this case doesn't break new ground on those. It just collects them all and puts a label on it and says that essentially every single one of those factors that it's cited before, maybe not everyone, but most of them are all present in this case.
And taking that back to Section 111D of the Clean Air Act, Jeff Holmstead, you had talked about how there were a number of requirements applicable to existing facilities with CO2 emissions. Some of those were heat rate improvements, and then there were some generation shifting requirements in the rule. And as I read the opinion, the majority opinion, those heat rate improvements would have been acceptable. That's something that you could do at a source to make it more efficient. But when EPA started to regulate with the aim to shift generation away from coal-fired power plants to natural gas power plants or to other sources of electricity generation, that seems like where the EPA really crossed a line in the view of this court. Would you agree with that breakdown?
Oh yeah, no. I think that's quite clear what they did. That had they stuck to what could be done to make a plant perform better from a pollution perspective, then that would have been kind of straight down the line as to what EPA has historically done under this provision. But by kind of regulating the industry as a whole and saying, okay, over time, a certain percentage, we're going to move the percentage of electricity in the United States from 35% to 20% over the next 15 years. That's where they said EPA had gone beyond its statutory authority.
And the majority opinion even quoted a few statements from EPA officials at the time who had really highlighted that as a consequence of the rule. And of course, any kind of regulation is going to have an economic impact on the regulated community. Costs of compliance are going to be passed on to the consumers of whatever services are used. But when that was the main target, right, was creating that sort of economic pressure, that seemed like that they really crossed the line.
And then EPA does quite a few regulations that are enormously costly and are enormously political. And when they change the NACs, those rules are likely to be more expensive than this one. But I think it's pretty clear, just because it's big and expensive doesn't mean that it meets the major question doctrine. That's clearly what EPA has done historically under the statute.
I did find it notable, though, as you mentioned, Daniel, that the majority opinion put so much emphasis on EPA's own words when they passed this rule. Many of those statements, and when they passed the rule, to sort of feed into the major questions doctrine. And so, made me wonder if that was one way in which this case could end up be narrow over the course of time. If this is a somewhat unique example where an agency was essentially walking right into a major question doctrine type of analysis.
I'd love to talk a little bit about the concurring opinion from Justice Gorsuch, if any of you have any thoughts on that. One of the things that jumped out to me, and this goes to something you had mentioned, Jeff Oldham, that we've seen the major questions doctrine before for decades, really, not just this term. But Justice Gorsuch takes quite a bit of time to root it in even more historical principles of federalism, of clear statement rules that have been used over a long period of time. Any thoughts on his concurrence and where the court may draw some guidance from his remarks in the future?
Well, as you say, he certainly did try to tie it to a much longer course of, kind of Supreme Court precedent than just the last few decades. But I think what was notable about the concurrence to me was just that the breadth of what the concurrence tried to take on in terms of both grounding this principle in separation of powers, and then also talking more about the history of the doctrine, but also the concurrence tried its own hand at the list of factors, both the list of factors of when you might have a major question, and then once you get to the major question, when is a congressional statement clear enough? And those lists somewhat relate to each other. They're not really independent lists in terms of when you have a major question and when Congress speaks clearly enough. So I think it provides a lot more guidance for people to look at in future cases. And something I'm sure we'll talk about is the impact on administrative law. But one of those is obviously going to be that you're going to see a lot more major questions, doctrine arguments raised against agency action. And I think his opinion, like the majority, provides a lot of fodder.
This has really been an area too where I think we've seen Justice Gorsuch in particular write for the public really about the significance of issues like non-delegation, the major questions doctrine, and other separation of powers issues. So it'll be interesting to see where people take it. There was a dissent in the case, a pretty punchy, almost Scalia-esque dissent from Justice Kagan, where she disagreed with the majority's holding. And we've talked a little bit about some of her remarks. She argued that this was the first time the major questions doctrine had really been used. And I think we all are probably in agreement that we've seen something like the major questions doctrine before. Maybe it wasn't labeled that way exactly, but we've seen it before. She really engaged with the statute, or attempted to engage with the statute, to say that what EPA was doing here was basically sort of classic gap filling, classic agency work to interpret Congress's delegation of authority, and to address new problems that emerge sort of after a statute has been enacted. What did you guys make of her arguments in her dissent?
Well, I mean, I think to one of the points you mentioned about the role of Congress to pass broad statutes and then have agencies do it over time, fill in gaps over time with rulemaking, was obviously very strongly on display in her opinion, as well as with the statutory analysis. And I think, the dissent's point is that Congress here did broadly grant power, and leaving gaps for agencies to fill in by rule is, sort of the dissent's view of government, good government. And I think it just reflects a very fundamental different view of, government than the majority opinion. The other, I think item that stuck out to me about the dissent too was the charge that the majority, although it said that the Clean Power Plan doesn't or wasn't within EPA's authority under Section 111D of the Clean Air Act, it charges the majority with not having provided really much guidance to EPA about what it can do. It simply said, what you did doesn't work, and didn't give EPA authority. And I know we'll probably talk about that in terms of what power EPA does have. But I think that was another line of attack that the dissent had that, as you said, was reminiscent somewhat of Justice Scalia.
I would say the thing that struck me most about the dissent is, for the dissent, it was all about climate change. And rather than talking about any constitutional principles or even jumping right into the statute, the first several pages talked about what a serious problem climate change is, the crisis that we have from climate change. And the implication was that this is such an important issue that we need EPA's expertise, and Congress intended to broadly give EPA this expertise, and so we need to let the agency should be the one to figure out how to address this crisis, and the worldview in the majority opinion is just completely different. They view it through a constitutional lens, and their view is this is a huge, important issue, and that's why Congress needs to address it before an agency can go off and do whatever it thinks best. But it was a pretty stark contrast. I mean, I do have to say, I think Justice Kagan made some good points, although I wish that I could have, in terms of the statutory interpretation, I think it was left wanting. But part of the problem is that there was very little of that in the majority opinion. Pretty limited analysis of the text of the statute. I always thought that under a traditional Chevron Step 1, the court would conclude that what the agency had done went beyond the statutory structure. But they didn't really even talk about this in terms of an interpretation of the statute, other than to say, we look in these provisions, and there's no clear statement here that Congress intended to give EPA this authority.
Yeah, let's talk about that for a little bit. I was thinking we might talk about some of the implications for President Biden's climate agenda, but let's jump into the administrative law implications of this decision, because I was very much like you, Jeff, thinking that, well, certainly Justice Roberts is going to explain how this relates to Chevron. Certainly, we're going to locate the major questions doctrine maybe as sort of maybe it's a Chevron Step 0, but it's still part of that Meade analysis. Or maybe it's Chevron Step 2. Maybe we recognize, hey, that statute is ambiguous, but you've gone too far and you've made an unreasonable interpretation of the statute when you filled the gap in that particular way. So what do you think some of the implications of this decision are for administrative law? And what questions do you think are still up in the air for the major questions doctrine and how we think about it in the administrative law context?
So I think the biggest question coming out is the Chevron issue, because, as you say, there's no mention of the Chevron doctrine in this case. Usually the major questions doctrine comes up in one of the steps of Chevron, Step 0, Step 1, Step 2. And here, it simply, there's no acknowledgement of the Chevron deference at all. It's just a clear statement rule, similar to how it was, I think, in the OSHA vaccine mandate case. But that follows, this case, not talking about Chevron follows on the heels of a couple of cases recently, including one very, heavily watched case where the sort of pleas to either erase or heavily revise the Chevron doctrine was before the court, and the court ended up saying nothing about it, simply interpreted a statute and didn't even acknowledge the Chevron doctrine. So I think that's one thing that we're going to have to wait and see in the future. But there seems to be a trend of simply ignoring Chevron, which is interesting, and I think something that merits a lot of attention going forward. In terms of the major question doctrine and what are the unanswered questions, at least for me, it's really just how far does it go? Because you're now going to see litigants challenging federal agency action raise it probably at every turn. And, there are some instances out there where already it's been charged. Can the Securities and Exchange Commission, have some sort of regulatory role in relation to climate change? I mean, that's, sort of one that I would guess that there's going to be some kind of a major question doctrine challenge. And there's others. There's other agencies, and Jeff Holmstead may, have some good examples from the environmental context or other contexts where, you have these arguments that, hey, this agency shouldn't be doing this. This is not their traditional role. They don't have a clear statutory grant. And so I think at this point, after what the court has now said here, less questions about the nature of the doctrine and more questions about exactly how far it's going to go and how often it's going to be applied are the questions that come to my mind.
The one the one thing about the relationship between this case and the Chevron doctrine, I think, comes from that footnote in the concurring opinion where Justice Gorsuch talks about, sort of a strong version of the major question doctrine versus the weaker version. And the weaker version in his telling is that when the courts interpret a statute, if they find it to be ambiguous, they would say that if there's ambiguity that the agency is using to stretch its statutory authority, then the major question doctrine would be used to resolve the ambiguity against the agency. And I think he's correct that what we got out of the majority opinion is not a weak version of the major question doctrine, but is a more muscular version. And I also agree with Jeff. I think the issues here are going to be in how it is applied and how it's applied in the future. My own view as someone who's been involved in a lot of EPA cases is I think the basic framework of Chevron will continue to be used. It is true the Supreme Court hasn't addressed it now in given a number of opportunities that it's had, but I think it's sort of a cautionary note that deference to agency interpretations of their statute have gone too far, and that that the lower courts on major questions should not simply defer to how an agency wants to read the statute. But I think on a lot of garden variety APA cases, that still will be the approach that is used. But we'll see. I've certainly heard people say this is the end of Chevron. Chevron is now dead. I'm not willing to go that far, but we'll have to see how it plays out.
Well, going back to the Kaiser v. Wilkie case, there another administrative law doctrine, our deference, or Seminole Rock deference, as it's sometimes called, was presented quite squarely to the court, and the court upheld it, more or less. They said that you need to exhaust the canons of statutory interpretation before deferring to an agency's interpretation of its own rules. But they did not take our deference out to the woodshed. And so I think we've seen the Supreme Court walk away from some of those invitations before. So I think that definitely makes quite a bit of sense.
Jeff, I was glad you mentioned that footnote from the Gorsuch concurrence, because that caught my eye as well when I read it. And interestingly, too, it essentially argues that the precedents in this major doctrine, not called major doctrine, but major doctrine precedents have usually applied the doctrine as a clear statement rule. And the court today confirms that this is the proper way to analyze it. And so in some sense, if that, reflects all six of the justices' views, then this is sort of turning the page, and is what, the future of the major questions doctrine is a major question or a clear statement rule as opposed to a Chevron principle.
Jeff Oldham, one of the questions I had after reading the opinions was that, was whether the major questions doctrine is something that the Supreme Court gets to use, or is it something that district and circuit court judges can use as well? Because I'm curious to hear your thoughts on how you think that judges in the Fifth Circuit or judges in the Ninth Circuit will use this doctrine or not. Will they let that be something really for the Supreme Court to do if it decides to take up a controversial case over a contested rulemaking, or will we see circuit judges follow the majority's invitation here and look at agency actions that sort of step out of line with their traditional deployments of power before? What do you think?
I mean, it's a good question. Obviously, I don't see any reason why only the 9 justices would have the authority to apply the major question doctrine. So I think it'll be an argument, routinely presented in the district courts and the circuit courts. And, it'll be interesting to see how it changes over administrations. Right now there's a certain, certain states are frequently challenging the federal government and their agencies' actions. And we've seen that over the course of the last several administrations that changes with administrations and works both ways. So it'll certainly be interesting to see how it gets used in cases and how many cases percolate their way to the Supreme Court.
All right. Thank you, Jeff Holmstead. Thank you, Jeff Oldham, for being with us. Dear listener, as we mentioned at the top of this episode, we are going to be breaking this conversation down into 2 parts. So do stay tuned. Do subscribe to our podcast so you get an alert when that episode is available. We will be breaking down how this decision might affect federal agencies and other aspects of the Biden administration's agenda to address climate change in our next episode. We hope you've enjoyed it, and thank you for spending some time with us here today. Talk to you soon.